I'd like to introduce Donna Chung, who's with the Japanese American Citizens League, also one of the plaintiffs in our case.
Hello, my name is Donna Chung, D-O-N-N-A, Chung, C-H-E-U-N-G. I represent the Japanese American Citizens League, Arizona chapter. I'm the current chapter president. Many of our membership have been directly and indirectly affected by World War II time incarceration in concentration camps, 2 of which were placed in the state of Arizona. Our membership understands directly what it feels like to be a member of a community that has been targeted. Therefore, it is our obligation to fight for the civil rights of all communities. It is our obligation as a membership who has experienced the darker sides of history to make sure that that dark side of history does not repeat itself in the United States. In 2010, we joined as a plaintiff in the lawsuit against SB 1070, and today we join again as a plaintiff in the appeal, and hopefully we will get a favorable appeal at the Ninth Circuit. We stand with all communities who are affected by SB 1070, as we stand with all communities who are targeted unfairly and unjustly. Thank you.
Thanks, Donna. So I just have a quick comment. I think it's no surprise to anybody here that certainly if we were here 5 years ago as a moving through the legislature, that SB 1070 was modeled after Joe Arpaio's divisive and discriminatory policies. Those policies have been already ruled unconstitutional in a separate case, but we believe that SB 1070 and the SB 1070 is no different. It still encourages racial profiling by police, and it's done and will continue to do the same amount of damage to our communities as some of Arpaio's policies have done.
Okay. Can I get you to give me your name again on the
Sure,
tape?
Alessandra Soler, Executive Director of the ACLU of Arizona.
And spelling, please.
A-L-E-S-S-A-N-D-R-A, Soler is S-O-L-E-R.
He's from radio, he doesn't know how to spell.
I'd be happy to take questions.
All right, now let's bring up let's talk to the attorney here. You're the one.
Well, she's an attorney as well.
No, well, but you're the one whose briefings I've been reading.
All right.
So let's talk about this. You know, you've got a couple of issues. One was discriminatory intent. You subpoenaed all of Russell Pierce's writings, the words wetback, Mexican, and everything else. You had a whole bunch of stuff there. The only thing I don't think you got was Jan's book. So the judge looked at that and said, I cannot find discriminatory intent. Tell me why you believe she missed that. What do you see in the evidence that she didn't see?
With the equal protection claim, if you reading the opinion, it becomes apparent that she found against us on a technicality that there was we failed to demonstrate that this law was going to be on its face targeting Latino community and the immigrant community. That opinion is based on it's problematic, is wrong, flat out wrong on a legal basis, because we all know the community that SB 1070 on its face will reach. And we all know the community that SB 1070's debaters and creators were attempting to reach. And we all know whom SB 1070 was trying to, whose practices SB 1070 was trying to codify and extend throughout the state. And not reaching those issues is a major problem with the opinion, and that's one of several things that we will be appealing.
Okay, the other issue came down to actually showing, look, this case went to the Supreme Court. The Supreme Court declined to declare it facially invalid, and said, come back with some evidence. Again, you had your opportunity to present evidence that it is targeting Hispanics, and again, the judge didn't see it. So tell me how you're going to convince the Ninth Circuit, you know, that what she missed.
Well, you know, we're still early on in the process. There's no appellate brief due just yet. We're noticing the appeal today, so obviously there's still some strategy in how we're going to present these issues. But there were evidentiary problems throughout the district court proceedings, and not everything we were entitled to, we were able to get, and not everything that we were able to get, we were able to effectively present. And those are issues that are going to be considered for this appeal.
And can I also just add, just as a follow-up to your question, Howie, you know, there have been lawsuits that have been filed, separate lawsuits that have been filed. There have been police departments that have settled lawsuits over the discriminatory application in 1070. That both, you know, the city of the Canal County, for example, has settled a lawsuit where a domestic violence victim had been in detention. Police departments who enforce SB 1070 are going to be liable for potential civil rights violations. So I think, you know, that has been one of our goals, is to kind of, you know, we have been trying to document these abuses and have been filing individual lawsuits. And I think that's the situation that we're in now. You know, I mean, police departments across the states are now a kind of a catch-22. They're living in a state where 1070 continues to exist, but they're also exposing themselves to potential civil rights violations. As a policy matter and as a legal matter, SB 1070 has failed, and we think every other state that has passed copycat measures ultimately ended up either they ended up settling those cases, or the legislatures in those states have said, you know, we made a mistake, they have some copycat measures. Arizona is the only state that has.
But it would seem that since the Supreme Court ruling, I guess it was 2012, the papers, please provision has been in effect. You should have had, for Judge Bolton, a litany, a laundry list of problems, and yet 2-3 years on, she didn't find it. That's my problem.
Respectfully, that she made a mistake, and that's what we're going to argue with. Does anybody have any other questions?
The U.S. Supreme Court has also decided in the Plyler versus Doe decision regarding the right of education to all constituencies within their bounds, regardless of nationality or citizenship status. In terms of the special resource officers assigned by the Phoenix City Police Department to the Phoenix Union School District and the standing of Section 2B, what are the implications for the community? What are the implications for the Phoenix Union High School District in terms of this apparent conflict on its face between these two positions of law at the level of the U.S. Supreme Court?
Yeah, so I think that the question Tupac raises a really good issue here, which is the fact that you know, we've got school resource officers in schools, and some of those examples that I cited earlier, we have documented examples where we have Phoenix police officers questioning students about their immigration status in schools.
Is it not a chilling effect on his face?
Of course it is, yeah, and I think that that's part of the problem, right? Is that what we don't want, and I think nobody wants to have police officers questioning kids in schools about their immigration status, because it obviously creates an environment of where those kids are in fear of being harassed, both the children and their parents. And so that just is an example of the reality. And I think what we've been trying to do is lobby the local school boards and the city of Phoenix to pass policies that protect students so that they're not being subjected to this kind of harassment in schools.